In this video, we'll continue our look at the UCC's Statute of Frauds by examining what the UCC requires for contracts that are subject to the statute. In short, Section 201 imposes a writing requirement for a contract to be enforceable. But remember, we do not even need to get to this question of whether there is a sufficient writing if the alleged agreement is below the $500 threshold and therefore not subject to the statute. But assuming an agreement is subject to 201, then the statute of frauds writing requirement has four elements. Remember that each of these elements is driven by the same underlying policy to allay the concern of fraud, to allay the concern that the party seeking to enforce the alleged oral contract, the plaintiff, is simply lying that there was an oral agreement at all. What are these four elements? First, there must be a writing or record. Remember that record is defined in Article 1, specifically Section 201B31, to mean any writing, whether that writing is in tangible or paper form or some kind of electronic form. Again, the writing serves an evidentiary function, allaying the concern that the plaintiff is simply making up the existence of the oral agreement. Second, the writing must be sufficient to indicate a contract exists, sufficient to show an agreement was reached between the parties. Again, the aim is to allay the concern that the purported agreement is simply a product of the plaintiff's fraud or perjury. Third, the writing must be signed by the defendant, the party against whom enforcement is sought. It won't do if the writing is signed only by the plaintiff, because the concern addressed by the statute of frauds is the concern that the plaintiff is simply making up the existence of the contract. To serve its evidentiary function, the writing must be signed by the defendant or the defendant's authorized agent, an agent acting on behalf of the defendant with the requisite form of actual or apparent authority. Remember also in this context that Article 1, 201B37 defines signature to mean any symbol, whether handwritten, printed, or electronic, that is used with the intention to adopt or accept a writing. Finally, the writing must state a quantity for the goods involved. This is not immediately clear from the statutory text. The statutory text does not expressly say that quantity is a required term. The only thing the text says is that the writing is not enforceable beyond the quantity stated in the writing. Implicit but not explicit in this language is that a statutorily sufficient writing must state some quantity. Official Comment 1 to 201 makes this point more explicitly, and it serves as an important reminder to always read the official commentary. Specifically, Comment 1 provides that the required writing need not contain all the material terms of the contract, and such material terms as are stated need not be precisely stated. The only term which must appear is the quantity term, which need not be accurately stated, but recovery is limited to the amount stated. So, in short, there are four elements to the writing requirement of 201: a record indicating a contract was made, signed by the defendant, and stating a quantity. Note what is not required. There is no requirement that the record of writing is the agreement itself. The record of writing is sufficient as long as it merely shows an agreement was reached between the parties, sufficient to allay the concern that the alleged oral contract is simply a product of the plaintiff's fraud or perjury. A written summary, description, or detailed reference to the terms of an oral agreement can suffice under 201, can serve as sufficient writing. Second, there is no requirement that the writing must include all the material terms of the agreement. For example, there is no requirement that the writing must state a price. This is a departure from the rule governing common law contracts. Under the common law, a writing satisfying the statute of frauds is required to identify all material terms of the oral contract with reasonable certainty. Under the UCC, however, only the quantity term is required in the writing. Third, there is no requirement that the writing be made contemporaneously with the oral agreement. The writing could be made later, after the oral agreement is reached. For example, subsequent correspondence between the parties that confirms the existence of a prior oral agreement could be sufficient writing. Fourth, there is no requirement that the writing be communicated or delivered to the other party. It could be obtained later in litigation through the process of discovery. Fifth, there's no requirement that one single document satisfies all the required elements. Several writings may be taken together, provided the multiple writings refer to one another or are connected together by internal reference. All that is required under 201 is that certain oral agreements must be evidenced by some kind of writing confirming the existence of a contract between the parties. So, to summarize, in this video, we looked at what kind of writing is required to satisfy the statute of frauds. As we'll see in the next video, however, even if we lack a sufficient writing, a oral agreement may still be enforceable under one of the many exceptions to the statute.